Get out the door this morning, and heading into the afternoon, it'll be cooler than average as well. It's a partly to mostly cloudy sky, highs in the mid to upper 50s. Partly cloudy and jacket weather again heading into Wednesday morning. Our lows in the mid to upper 30s with a little improvement in afternoon temperatures. Partly cloudy Wednesday, highs in the mid 60s. I'm meteorologist Chris Michaels in the NCN Weather Center.
Heavy load, heavy load, I got rid of my heavy load. Say it again, heavy load, y'all. Heavy load, yeah, I got rid of my heavy load. Look at that lady right there.
All right, good morning, and welcome to Making the Law Work for the People here on WIDU 1600, sponsored by Brent Adams and Associates. My name is Chris Winker. I am one of the litigation attorneys here at Brent Adams and Associates. We have altogether five litigation attorneys. And here at Brent Adams and Associates, we are here to help you with some of the legal issues that you may encounter, from workers' compensation to disability claims to compensation for personal injuries or various other situations you may encounter. We hope you will call us when you need assistance. Our motto here is, don't hesitate, call the 8s. That's 910-888-8888. Again, that number is 910-888-8888. 8888. So if you have been injured through no fault of your own, don't hesitate, call the 8s. We have several offices across North Carolina. The main office is located in Dunn at 119 Lucknow Square. That's 119 Lucknow Square in Dunn. We have an office in Fayetteville. That's at 1300 Pamela Drive, Suite A. Again, that's 1300 Pamela Drive, Suite A. We have a Raleigh office, which is where I happen to be located, and that's at 8222 Creedmoor Road. That's 8222 Creedmoor Road. It's conveniently located near I-540 and Creedmoor Road, or otherwise known as State Highway 50, or U.S. Highway 50. And then we have an office in Southern Pines that's located at 105 East Massachusetts Avenue. That's 105 East Massachusetts Avenue. So if you need to find us, you can find one or more of us at any one of those locations. We also are online. You can visit our website at brentadams.com. That's www.brentadams.com. And there you can see more detail about our firm, including how to get in touch with us, our phone numbers, contact form, things like that. If you want, you can find us on Facebook or other social media. Just search for Brent Adams and Associates on Facebook, or I think we may also be on Instagram now. But in any case, that is a good way to learn a little bit more about the firm and the people who work here and get some tips and pointers that might help you with your situations. You can find us on Google as well. We do have a Google Sites listing, and there you just Google Brent Adams and Associates, and you will find our Google listing. You will be able to see some feedback from people that we've helped throughout the years and get some more information about the firm and how to contact us. And if you have listened to this program or worked with us, been a client of ours, and we've helped you out, and you've appreciated the work that we've done for you, please leave us a review. A 5-star review is always much appreciated. There's not enough positive feedback in the world these days. So leave us a 5-star review over on Google, and we really would appreciate that. Well, let me tell you a little bit more about Mr. Adams. He's been practicing law here in North Carolina for more than 50 years. That's a lifetime. And during that time, he's written several books. Those titles include 10 Costly Mistakes That Can Wreck Your North Carolina Case, also How to Get Top Dollar for Your Workers' Compensation Claim, as well as the truth about medical malpractice claims. Now, you can find any of those books on Amazon.com, but even better than getting them from Amazon, you can call our office at 910-888-8888. Tell them you're a faithful listener of WIDU 1600 and that you heard our program there. And we can send you a copy of one of Mr. Adams's books, and maybe we'll even be able to get him to sign off on it for you. You can have an autographed copy. Well, today I would like to talk about an issue that comes up in pretty much every single case, and that's when you get your money, now what do you do, right? So I like to call this, I got my money, now what? And there's actually a lot that goes on after a case is settled or resolved at trial before we can get all the things finalized and get money sent to you. Actually, in many ways, getting the settlement is just the first step towards resolving your case. Sure, a lot of work goes into that. We spend a lot of time preparing our cases, getting everything together, analyzing them, and negotiating with the insurance company or with defense counsel. And we spend even more time getting ready for trial and trying a case. Dozens of hours go into that. And so once we get a verdict from a jury, we've already invested maybe even 100 hours in a case. But that doesn't mean that everything is over at that point. There's still a lot of work to be done. And so I will tell you all today about what we do once we have that win, that settlement amount or that verdict, after we get the check. But I'll tell you a little about what it takes for us to get the check and then what we have to do to get the rest of the money to you. There are actually several things that we need to make sure are taken care of. So if you have a settlement and or a verdict and you want to get that resolved and make sure that everything is taken care of, you would be best suited to have a good attorney experienced in those issues, such as the ones that we have here at Brent Adams and Associates. You can get our assistance with these things by dialing the 8s. That's 910-888-8888. That number again is 910-888-8888. Okay, so as far as getting a check, once we've come to an agreement about a settlement or we have won a trial and secured a verdict, we have to get the check. It doesn't just magically appear in our account and allow us to send money to you. Typically, what we have to do to get the check in a settlement is we have to do some paperwork. If it is just a straight liability settlement where we have negotiated with the at-fault party, the people who caused your injury, and we haven't gotten all of the money that's in their policy, in other words, we haven't gotten the policy's limits, then typically we will have to have a release. And I don't want to go into too much detail about a release here, but basically a release is a document that says that you have settled your claim and you are giving up the opportunity to get any further money on that claim. So we need that paperwork to be signed by you, and then we would send that to the insurance adjuster or defense counsel or whoever it is that we negotiated with, and that will show them that we've upheld our part of the bargain. We have agreed that this is going to be a full settlement. Then they will send us the check, typically. Now, if we have settled for policy limits, there will be a different document that's called a covenant not to enforce judgment, but it serves much the same purpose. You sign off on that, you're giving up your claim against that insurance company, and then they can send us a check. Either way, there's paperwork. We have to get the paperwork signed, and then they send us a check. Now, once we receive the check, then we have to put it into our trust account. Our trust account is an account that all lawyers have, and all lawyers that deal with other people's money. And the money goes into there, and it's not our money. It's not Brent Adams and Associates money. It's your money. And it has to stay there for at least 10 business days so that we can make sure that it's a good check. Even though we get dozens, hundreds of checks from some of these insurance companies, we still have to verify that the funds have actually cleared the bank. And so that's why we're required to let it clear our trust account before we can distribute it. Now, if we've gone to trial and gotten a verdict, the paperwork isn't necessary. All we need is the judgment. But then once we have that judgment, we can get the check, and everything is the same. So the only difference is settlement, paperwork, verdict, judgment, no paperwork. Then the check clears our trust account. Now we can spend it. And we're not spending it just willy-nilly. There are several things that we need to make sure are satisfied from that judgment. The first thing that will come out of that judgment or settlement or whatever the check is for will be our fees. I know that sounds kind of ruthless and mercenary of us, but we are running a business here after all. We do have bills that we have to pay. We have employees whose paychecks we have to pay, and we need to make sure that that gets done. There are also, of course, lots of other expenses that we have just to run an office. We have to keep the lights on and things like that. So we have to take our money by earning money for you. Now, what do you get for that money? Well, if you've listened to all of our other shows, you understand the work that we do here and the things that we accomplish to make sure that we get the most value for our clients' cases. That is the number one thing that we do for our clients is we provide them with added value to their case. We make sure to look in the right places to find out what your injuries are, to find out what damages you have, to make sure to properly explain your pain, your suffering, to represent the lost income that you may have had or future lost income or opportunities that you may have lost as a result of this. That is our bread and butter. That is what we do best and why we charge the fees that we do. Now, fees can vary from attorney to attorney and from case to case. Some attorneys charge as little as 25% for certain kinds of cases, and some attorneys charge up to 50 or even 60% for certain kinds of cases. It all depends on what the lawyer is doing. Typically, having to appeal cases and having to litigate that in the Court of Appeals or the Supreme Court requires more time on our part, more effort, more work. And that's when typically we would charge more money. Going to trial can take a tremendous amount of time. It can easily double the amount of work that's been done getting to that point. And so typically that will cost a bit more money. But it is important that you understand up front what fee you are agreeing to pay, and that should be set out in the contract with the lawyer. So make sure that you look at that and that you understand. And if you have any questions, ask about it. You should always feel free to ask your attorney questions, especially about things dealing with your relationship with that attorney. What fee they're getting, what your expectations are of them, and what their expectations are of you. All of those things go into determining the fee. So make sure that you understand that. But that will come off the top. We will take our fee first, except in a very few situations where we might not be able to get a fee. And then the remainder will be used to pay the client and satisfy other things. Well, what are those other things, you may ask? If, for example, your attorney has taken a 1/3 fee, well, shouldn't you get 2/3? That would be what most people would expect. But the truth of the matter is that there are a lot of other things that may have to be paid out of that recovery. And in many of those situations, we as the attorneys have no choice. We are required by law to pay those certain things out of your settlement or your verdict. Well, what are those things? Well, there are costs associated with a case, and there are liens, and then there may be other legal obligations that are required to be paid out of your recovery. And I'll go through each one of those and describe and explain them in some detail. But the first one is costs. Now, costs are different from fees. A fee is the money that an attorney earns just for the work done on the case. That is separate from costs, which are monies that have to be spent on the case. Well, what does that mean? What's the difference, Chris? You may be asking. And the difference is the fee is just for the attorney's work. The costs are for things that are imposed by other people, such as a court or a medical provider, such as your doctor, or the sheriff's department, or a private investigator. All of those things can be considered costs. They are not monies that we are taking. They may be advanced by us. We might pay them up front and then take that cost out of the settlement. And many people have asked, well, if you're the one spending the money, why isn't that just your overhead? Why isn't it that getting my medical records is just part of the cost of doing business for you? And unfortunately, we're not allowed to do that. That is actually considered a conflict of interest for attorneys, and we're not allowed to just pay the costs out of our own pocket. And the reason is that we might decide not to pay some of those costs because we don't want to get less money in the end of it all. So ethically, we are required by the laws of ethics that govern attorneys to make the client responsible for any case-related costs. And good attorneys, such as those here at Brent Adams and Associates, will make sure that those are explained to you up front, that you understand what those costs are, and if there's a significant expense, that you get the chance to discuss it with your attorney and approve or disapprove of that cost. So here at Brent Adams and Associates, we make sure to talk to you about anything that's going to be really expensive, such as hiring an expert witness that will be necessary to win the case, but that may cost $5,000 or $10,000. Similarly, hiring a private investigator. That can be a significant expense. And if you would rather not incur that expense, then that's up to you. Minor, typical, and routine costs, though, are not something that we typically run by our clients. So there's a fee to file a lawsuit in court. And we typically just go ahead and pay that and take it out afterwards. We let you know that we're filing a lawsuit and get your approval for that. And if you ask, certainly we'll talk to you about the cost of it. But that's something that is very routine, and so typically we don't double check with a client first. Similarly, sending out a process server, whether it's the sheriff or a private process server, that's something that has to be done, and so we just go ahead and incur that cost. But typically all of these kinds of costs are no more than a couple of $100 and usually a lot less. Most medical records, for example, are going to be about $20 to $50. And that is not something that's going to be significant considering the money we're going to get back for you. So we just go ahead and front that cost and then take it out at the end. But that is something that will come out of whatever we recover for you, whether that's a settlement or a verdict. And so if you have questions about what those costs are in your particular case or what they could be in a case that you have coming up, feel free to give us a call. You can call us here by dialing the 8s at 910-888-8888. That number again is 910-888-8888. Ask one of our experienced staff about costs, and we'll be happy to answer your questions about that. Okay, the next thing that I want to get started on here just before we get to the break are liens. That is one of the biggest areas that we typically deal with when we are resolving somebody's case, when we've got the money and we're trying to figure out how much we can pay to our client. Liens end up consuming most of our time in this regard. And a lien, much like a lien on your home or your automobile, is a legal obligation that you have related to that money to pay to somebody else. Most often, that is going to be either some sort of insurance company, your health insurance, or a medical provider, your doctor or the specialist who treated you for your traumatic brain injury or performed surgery or something like that. Those are the entities that we deal with most regarding liens. Now, you may be asking, well, why would I have to pay my insurance company back? That doesn't seem fair. Aren't they just supposed to go ahead and pay my health expenses? Well, unfortunately, not always. Sometimes you can just accept their help, the medical care that they provide, and not have to worry about paying them back, but sometimes you do have to pay them back. In particular, all of the government-provided insurance programs are required to be paid back. So that's Medicare and Medicaid, but also the supplemental plans that are distributed or managed by a private entity. And I'll be honest with you, I don't really understand how most of that works, which is why I am so happy that here at Brent Adams and Associates, we have someone who specializes in dealing with those issues. Our lien specialist knows all about Medicare and Medicaid and all of those government-provided insurance programs, what they expect back as far as their payment, and how to deal with them to make sure that the appropriate amount is paid. So, unfortunately, if you have government insurance, on the bright side, it can pay for your care while we're waiting to resolve your case. They do a great job of paying for medical care while we litigate your case. But then at the end, after everything is done, they do expect to be paid back for the money that they have spent on your behalf. That's required by law. And we have a lot of experience in dealing with that. We have specialists here who that's her entire job, really, is dealing with those issues. So you can feel comfortable and assured that when that issue comes up, we here at Brent Adams and Associates will be able to help you with that and to ensure that that's handled properly. Now, when we get back from the break, I will discuss a little bit about how we do that and what you can expect. But for now, enjoy these messages, and I'll see you on the other side.
Look at that lady right there. This is Pastor T.C. Lee, Smith Temple Church of God in Christ. You are listening to Wake Up.
Everyone needs to take care of their mental health, even running back Bijan Robinson.
When I'm on the field and feeling the pressure, I usually just take a deep breath. When I'm just breathing and seeing what's in front of me, everything just slows down. It just makes me feel great before I run the play.
Just like Bijan, we all need a strong mental game on and off the field. Make a game plan for your mental health at loveyourmindplaybook.org.
Love your mind.
Brought to you by the Huntsman Mental Health Foundation, the Arthur M. Blank Family Foundation, and the Ad Council.
Long lines at the nation's airports are getting longer as more TSA officers forced to work without pay call out sick. 2 years after legalizing online sports betting in March of 2024, North Carolina has yielded more than $250 million in tax revenue as of early 2026. New Hanover County's elections director will remain on administrative leave following a nearly 3-hour board meeting on Monday night. Pollen season is definitely here. Dr. Edwin Kim, chief of pediatric allergies at UNC Health, says that no sprays can help with most of those problems. A major global study of the world's freshwater migratory fish have found more than 300 species in decline. Samaritan's Purse is providing lunch to TSA workers impacted by the ongoing partial government shutdown at the Billy Graham Library in Charlotte. Mike Rayleigh, NCI News.
I'm Jamie Monticelli, WIDU Radio News. The Cumberland County Sheriff's Office is alerting the public to a recent scam and robbery scheme occurring through Facebook Marketplace in the Everett Acres subdivision off Lake Upchurch Drive in Parkton. Detectives have gotten reports of an individual advertising air conditioning units for sale at discounted prices. When buyers arrange to meet and arrive at the location, they are directed to the rear of the residence. Once there, the suspect approaches the victim armed with a firearm and demands payment. Victims are forced to either surrender cash or transfer money via a Cash App account. Reported losses from those incidents have ranged from $900 to $6,000. Join the community for another youth night out. The Proof Project is teaming up with the Office of Community Safety and other organizations for a youth night out April 10th, 7 p.m. until 10 p.m. This is at Roundabout Skating Rink. Youth ages 13 to 18 are invited. From WIDU Radio,
Tuesday morning starting out much colder than yesterday morning thanks to that cold front that passed through just yesterday. Things are going to be significantly cooler, at least through today. High temperatures mid to upper 50s with more of a blend of clouds and sunshine. Overnight, it's partly cloudy. Temperatures dropping to about 35 to 40 degrees. And by Wednesday, a little improvement in our temperatures, partly cloudy and highs, making it into the middle 60s. I'm meteorologist Chris Michaels in the NCN Weather Center.
Arise, a musical production sponsored by Family Faith Temple Ministries Incorporated, coming to you on Sunday, March the 29th, 2026 at New Bethel AME Zion Church, located at 6967 Amarillo Drive in Fayetteville, North Carolina. The tickets are $10 for adults, $5 for children. You will pay by Cash App at $ capital FAM, capital FAITH, capital TPLE, capital MIN, capital INC. The doors open at 4:30 p.m. It starts at 5. Arise. See you there.
You have always put others before yourself. Put your country above all else. Given everything you can, every time. Now it's time to forge a new path. At Fayetteville State University, we believe your service is our debt. So we're offering free military family tuition. Yes, absolutely free. And with new programs like cybersecurity, anything really can happen. Fayetteville State University. Are you in?
Heavy load, heavy load. I got rid of my heavy load. Say it again, heavy load, y'all. Heavy load, yeah. I got rid of my heavy load. Look at that lady right
Okay. Welcome back to Making the Law Work for the People here on WIDU 1600. Sponsored by Brent Adams and Associates. Again, my name is Chris. I'm one of the litigation attorneys here at the firm. I am in the Raleigh office. That's located at 8222 Creedmoor Road up in Raleigh. That's 8222 Creedmoor Road. Our main office is located at 119 Lucknow Square in Dunn. That's 119 Lucknow Square in Dunn. We have a Fayetteville office. That's at 1300 Pamela Drive, Suite A. Again, 1300 Pamela Drive, Suite A in Fayetteville. We also have an office down in Southern Pines at 105 East Massachusetts Avenue. That's 105 East Massachusetts Avenue in Southern Pines. But the easiest way probably to get in touch with us is to just dial the 8s. If you've been hurt and you need some help, don't hesitate. Dial the 8s. That's 910-888-8888. Again, 910-888-8888. So before the break, we talked a little bit about the liens that will need to be paid from whatever we recover for you, whether that's through settlement or by going to trial and getting a verdict and a judgment. And the biggest of those are the government-provided health insurance liens, typically Medicare and or Medicaid. Now, federal law provides that Medicare can take all of your settlement or all of your judgment. They could take the whole thing. Of course, that would be patently unfair in most cases, and the law recognizes that, and it allows Medicare to pay less than the full amount that it feels is due. And so we will typically negotiate with Medicare, Medicaid, or other government-provided health care programs, and that includes the school employees health plan, the public safety employees health plans, all of those ones that are provided by the government that have a statutory right to recover from us. We'll negotiate with them. And that is part of the work that we do here at Brent Adams and Associates. So we will let them know how much money was recovered, but more importantly, we'll tell them how much they should take from that and negotiate with them on that issue. There is a statute here that applies to other situations that says that the most that a lien holder can get is half of whatever your net recovery is after attorney's fees. So if your attorney's fees are a third, then the most that a lien holder could take is a third. Now that, as I just said, doesn't apply to the government the government health insurance programs, but we typically will try and keep them to a third anyway, so that that law that applies to everybody else can also provide guidance for the government programs. And typically we have some pretty fair success in accomplishing that. So even with Medicare and Medicaid, the big federal bad guys who could take all of your money, at least Medicare can, we do our best to convince them to take less than that so that you will get as much money as we can get for you from your recovery. And as I said before, we have a person here on staff whose whole job is dealing with those people, and she does a really good job at convincing them to take less than they initially have demanded. So if you're in that situation where we've gotten you a big recovery, or even if somebody else has gotten you a big recovery and you need help dealing with those government health insurance plans and how much they want to take away from that recovery, you can get in touch with us by calling us. Don't hesitate. Dial the 8s. That's 910-888-8888. Now, there are other kinds of health insurance plans besides the ones that are provided by the government. There are many that are provided by your employer. They're just private health insurance. Some people have gone out onto the Affordable Care Act exchanges and gotten health insurance that way, and that is something that we see a lot of as well. And those health insurance companies may also be expecting to get paid back from the recovery for whatever money they have paid out. The good news is that unlike those government-provided plans, they're not automatically going to get money back necessarily. They can send us a lien, and they can tell us that they're expecting to be paid back. And if they perfect their lien, in other words, if they give us the proper notice of it, if they do it the right way, then yes, we are obligated to pay them. But as with all of the other insurance programs, we can negotiate with them as well. And we do so regularly. I routinely suggest to them that they take significantly less money than they want from us. And we can usually do a pretty good job of convincing them to accept that and resolve your lien that way. Now, one thing that's important to know about these liens is just because you've paid one of these insurance companies through their lien from whatever your recovery is, that doesn't mean you don't owe them any more money, right? The law allows them to take the money from your settlement, and it limits the amount that they can get, typically to 1/3 of the total. But that doesn't mean that's all they can ever get. It doesn't extinguish the debt. It just limits the payment from your settlement or your verdict, that statute. So what we here at Brent Adams and Associates will usually do for our clients is to negotiate with them to take a lesser amount and accept that as payment in full. So that is a commitment that we make to our clients so that when they walk away from their legal case with us, they don't have any medical debt as a result. And that can be done, but it does require some knowledge and experience in dealing with those issues and the people that hold your liens. So make sure that if you're in that situation, you get good, competent, qualified legal help like that we have here at Brent Adams and Associates. Okay, so in addition to your health insurance program, there are other entities that may have liens against your settlement or verdict. And the biggest one of those is healthcare providers. We deal with lots of healthcare providers who are expecting to get paid from the settlement or from the verdict. Now, sometimes those people do not bill your health insurance. Most of the time, that happens to be the case. Sometimes they will provide care to you and not charge you up front and expect to take their money out of your settlement or out of your verdict at the end. That can be a good way for a needy client of ours to get health care when they can't afford it or if they don't have health insurance. And we're very experienced at dealing with those kinds of healthcare providers. We know many of them and are able to ensure that our client gets the care that they need smoothly and in the time that they need it. Then once we deal with getting the money from the verdict or the settlement, then we can deal with those lien holders. But sometimes they just send you a lien. They ask you to sign the paperwork when you go in to get the treatment, and then they send us the paperwork. So in any case, as I said, there are requirements for these healthcare providers to perfect the lien, to do it according to the law. And we make sure that they have followed those steps. There are several very specific steps they have to take, some very important requirements that they have to satisfy in order to be able to claim that lien. We have dealt with lots of different situations where a healthcare provider has asked for a lien, and sometimes they're a little bit different, and we have to check to make sure that they've done it the right way. And if they haven't done it the right way, then their lien is invalid, and they're not entitled to take any money out of your settlement or your verdict. Now, that doesn't mean, as I said, that they can't demand payment outside of that. that they can't pursue payment from you the old-fashioned way, sending it to a collection agency or whatnot. But typically, they try to get their money out of the settlement, and they mostly do a pretty good job of satisfying the lien statute and doing it the right way. But again, it is important to make sure that those steps are followed properly and the lien is valid before you go ahead and satisfy that. And so if you have questions about that, consult a qualified and experienced attorney like those that we have here at Brent Adams and Associates. If you have questions about liens, don't hesitate. Call the 8s. That's 910-888-8888. Again, that's 910-888-8888. Okay, now there are certain circumstances where there's a healthcare provider who has not asserted a lien, that has not given us the notice that they have a lien and are expecting to get paid out of your settlement or your judgment. But you should pay them anyway. And the most common of these that we experience is the emergency medical services that were provided to you. So if, for example, you were involved in a car crash, somebody crashed into you in the side of your car and maybe rolled it over a few times, and you're injured and they have to come and pry you out of your vehicle with the jaws of life, and an ambulance comes and paramedics are at the scene administering life support to you, and then they whisk you off to the hospital, those people are going to expect to be paid for their service. Ambulance companies, that is how they typically operate, is they get some taxpayer money, but they also have to bill for what they do. If you have health insurance, a lot of times they'll bill your health insurance. But if you don't, or sometimes even if you do, they'll send you a bill directly. And that should be paid. Fortunately, EMS bills are typically not astronomical, not like going to the hospital and having surgery. EMS bills are fairly reasonable. They can sometimes amount to quite a bit, but they're usually not so significant that it will take up all of your settlement. And even though they don't assert a lien, it's wise to pay EMS companies because they can intercept your taxes. They can get money that you would otherwise be expecting if you have a tax refund that's due coming from the IRS. They can actually intercept that and get paid out of that. Similarly, if you're receiving other forms of government benefits, some of those benefits can be intercepted by EMS companies to satisfy an outstanding bill. And so that's why here at Brent Adams and Associates, whenever we have a client who received EMS services and was transported to the hospital, or even if an ambulance just showed up and left them at the scene, if there's a bill from them, we always do our best to make sure that gets paid so that they don't come after other money that you're expecting from the government that you may be relying upon for your daily expenses. Again, that's usually not a tremendous amount, and it doesn't usually make a huge difference in the outcome of a case, but it's important to make sure that gets paid. And so we will contact them. We will find out what it is that they expect to be paid. If we can have it paid through insurance and get a reduction in that amount, we'll do so. But in any case, we don't want any benefits that might be due to you, such as a tax refund, to get intercepted by them. So EMS is very, very important to consider and to make sure that they are paid. There may be other, not exactly lien holders, but government-related payors that are expecting to get paid back from your settlement or your judgment. And those can include things like child support or, government loans, things like that. there may be other entities that have some legal requirement for you to pay them out of any kind of recovery that we could get for you. So if you happen to know that you have one of these obligations, if, for example, you have a court order requiring that you pay a certain amount of money and providing that, or if there's a law that provides that any money you get can be used to satisfy that, it's important to bring that information up to your attorney. So please let us know if you have any of these obligations. Sometimes we find them out through other means. A lot of times these places have ways of finding out when you are expecting some money, and they'll get in touch with us and they'll say, hey, we just wanted to let you know that your client is obligated to pay the certain amount of money for court-ordered obligation, and we expect that from your recovery. Again, as with pretty much any other lien holder or person who is a creditor of yours, that there's a legal obligation that you pay them, we are usually able to negotiate with them so that they don't take all of the money that you're getting from your settlement or from your verdict. We are able to convince them usually to accept a reasonable amount and continue on their way. Now, unlike the other kinds of obligations that we negotiate with and get to be paid in full from whatever it is that we negotiate with, court-ordered obligations we usually cannot, because a judge has ordered that, and only a judge can change that amount. So this is one of those rare situations where we can reduce the amount that gets paid from your settlement or from your judgment, but we cannot extinguish that debt. So that usually remains even after we have made that payout, and we'll make sure that you understand that when that situation comes up. But if you have any questions about that, you've got that coming up in your case, and you want us to help you figure that out, don't hesitate. Call the 8s. That's 910-888-8888. Again, that number is 910-888-8888. And we have staff and attorneys who are here happy to help you figure that situation out in your case. Okay, so then there are other things that we can pay out of your settlement or verdict that are not health insurance or healthcare provider liens, not EMS, or not some court-imposed obligation. These are typically totally voluntary for you to pay from your settlement or your verdict. You do not have to, and it's up to you to decide whether or not you want to just keep the money or have us send it to these other places. And that can be medical bills that didn't have a lien. If you have a big doctor bill from your crash and either they didn't follow the process to perfect a lien, or they just sent you a bill and didn't bother to provide notice of a lien, we can pay that, even though there's no legal obligation for us to do so, if you want us to do that. So if you choose to pay other medical bills, just let us know. We'll take care of that. Similarly, there may be other kinds of bills that you want to be paid out of your recovery, and you can let us know that. One that has become increasingly common is a loan that is taken against your settlement outcome or your verdict that then is to be paid from that. That is one of those gray areas that is sort of like a lien and sort of not like a lien. Typically, we consider those to be liens because our client signed some agreement to that effect. But that is an area that is really not as clear-cut as just a standard statutory healthcare provider lien. if you're considering taking out a loan against your settlement or your verdict, I would recommend that you strongly consider some other way of handling that financial situation. There's usually a very high interest rate to be paid from that that takes a pretty sizable chunk of your settlement or your judgment. But ultimately, it's your money, it's your life, and it's your decision. But there are other kinds of loans or obligations that our clients sometimes ask us to make sure are satisfied, not related to their lawsuit. There may be a car payment or a house payment or just a gift to a relative or something. It's typically not wise to include that as part of your personal injury claim, but if you direct us to pay a certain amount to a certain obligation of yours, then we can do that, though it typically is not a wise idea. And the reason for that is that this should be really just related to anything dealing with your personal injury. If there are completely unrelated bills that you want paid from that, it can complicate things from a financial and even maybe from a tax perspective to get involved with all sorts of other payments. Typically, it's best for you to accept all of the money that's remaining from your settlement or your verdict and then make those payments yourself to other people. Sometimes we will set up a trust for our clients, particularly those who have special needs or who are minors, and then that can be used to pay those things. But those are special circumstances. Those are not your typical car crash kind of case that is the thing we deal with most often. So to wrap up, again, when we get you some money, whether it's by negotiating a settlement or going to trial and obtaining a verdict and a judgment, that is not the end of the story. There is still a lot of work to be done after that happens before your case is completely over and closed. First, we have to get the check, which will typically require some paperwork that you will have to sign off on. Once we have the check, then we have to let it clear our trust account to make sure that the money is actually there. Once it has cleared the trust account, then we have to satisfy all of the payment obligations that we have on that. First of which is our fees. We will take our fees off the top. We will also take out any costs that are associated with your case. And again, that's things like the filing fee for going to court, paying a mediator or a private investigator or a process server. Sometimes we have to hire an expert witness. All of those are costs. Then there are the liens. Those can be from government or private health insurance plans. That can be from healthcare providers who have gone through the proper procedures to make sure that they've given us notice of the lien. That can be from other sorts of legal obligations that you have. Once all of the liens are satisfied, then we, of course, will have to pay off any government-provided benefits like EMS and make sure that any other court-imposed obligations are taken care of. And then there may be health providers. Okay, well, thank you so much for listening to me here today on Making the Law Work for the People. Again, if you have any questions, don't hesitate. Call the 910-888-8888. Take care, everybody, and have a great day.